Hello everyone, topic Plaque in justice system. It is unfortunate that adjournments have become a plague for the country's justice system. On 31st December 2023, a net pendency of 2.36 million cases was reported in the country, and 1.86 million of the cases out of the total pendency, which is around 82%, are pending adjudication before the District Judiciary. And despite this mammoth pendency, which undoubtedly has only grown since 31st December 2023, the adjournment culture continues unabated, which robs litigants of the right to speedy justice and further exacerbates the inefficient judicial system crisis. The failure of the courts to deal promptly with backlogs involves very human, Naeem consequences. Controversies are prolonged, hard feelings emphasized, families suffer privation from their inability to obtain relief. As a result, people seeking relief become embittered and hate the courts and the law because the legal profession has not lived up to its responsibilities in a field where its responsibilities are primary and almost exclusive. Having said that, adjournments cannot be used as a delaying tactic, nor can they be demanded as a matter of right. And yet the reality is quite different. Adjournments cannot be demanded as a matter of right, and Rule 1 of Order 17th of CPC, as reproduced above downs, is perspicuous in Naeem this regard, as a court may grant time and adjourn, and that too if sufficient cause is shown. It is only logical that this sufficient cause may only be shown by way of an application in writing, meaning that any party to a suit or any other proceeding before a court can request an adjournment only if it satisfies the court by way of submitting an application for adjournment in writing, along with evidence attached of the predicament or ailment that they are facing, for which an Naeem adjournment is the only solution. It is then up to the court whether to accept the adjournment application or to proceed with the matter at hand. If the court is to accept the adjournment application, then it must immediately decide on whether or not to impose costs to the party requesting an adjournment. The decision on costs is necessary for multiple reasons. Frivolous adjournments incur a significant cost and are a gross misappropriation of the already limited court funds and facilities. The cost of a court to be in session, the salaries of all parties involved, and maintenance of the courtroom are, Naeem, just a few of the expenditures and facilities which are not being utilized every time there is an adjournment granted on dubious grounds. It is also an unjust and inexcusable charge on the litigant's pocket, as many parties to the suit suffer great losses in the form of travel costs, opportunity costs, and daily wages. Furthermore, an unseen but deeply felt social and psychological cost is also borne by litigating parties. It is pertinent to state here that once a decision on whether or not to impose costs for seeking an adjournment has been taken, the court has to record the reasons for granting an adjournment and why or why not costs have imposed on a party which sought adjournment. On the flip side, what happens when a court does not allow a request for adjournment? The matter is to proceed as envisioned in Rule 3 of Order 17 of CPC. Rule 3 uses etc. at the end of its title, which would encompass everything else apart from production of evidence, and further states that if any party to a suit fails to perform any other act necessary to the further progress of the suit for which time has been allowed, the court, notwithstanding such default, proceed to decide the suit forthwith. See PLA 2849 L 2015.